again. Good afternoon. This is Dr. Olu Asekun here. Welcome to our podcast. Today is another Wednesday. This program is every Wednesday, 12 p.m. Central Standard Time. Today is another Wednesday. Welcome to our podcast. Today, we'll be discussing waivers. We'll be discussing waivers today. There are situations where an applicant may be ineligible for a benefit, either an applicant who is based in the United States or an applicant who is based outside the United States. An applicant can apply for a benefit, apply for a particular set of status and not be eligible for so many reasons. People can be inadmissible based on misrepresentation, prior or current misrepresentation. People may be ineligible based on criminal convictions, based on criminal record. People may be ineligible based on medical ground, and people may be ineligible based on prior immigration violations. So, for many of these, there are waivers that an applicant can apply for. There are two categories of waivers. We have the non-immigrant waiver, not very common, but it is available. And of course, we have different set of immigrant waivers. So when we talk about different set of immigrant waivers, we are talking about maybe waiver based on prior immigration violations, maybe waivers based on fraud or misrepresentation, or maybe waiver because of criminal conviction. Now, the non-immigrant waivers, like I said, is not very common. It is possible, but not very common. The issue is, for non-immigrant waivers, applicant can only apply outside the U.S. through the consulate, even though the waiver application will be adjudicated in the U.S., but applicants usually will have to apply from outside the U.S. And in order to do that, because it's a non-immigrant, applicant will have to explain why coming to the United States is so important to the applicant, and what the applicant is coming to do in the United States that is so valuable, so important, that denying him or her the visa will create substantial issue for the applicant. So applicant will have to go through all of those explanations. Usually, applicant, in addition to the application form and the application fee, applicant will have to write a very detailed sworn statement explaining why the applicant was inadmissible in the first place, and then explaining why the waiver should be granted. So, because this is a non-immigrant waiver, like the non-immigrant status itself, it is 100% discretionary. So it could be denied with or without reason. The other type of waiver is the one we use for immigrant situations, immigrant benefit waivers. There are different types. One could apply for waiver based on prior misrepresentation, based on current misrepresentation, based on prior criminal convictions, even based on prior or even current grounds of inadmissibility and other grounds of inadmissibility. So an applicant could be inadmissible, maybe because the applicant has lied in previous application, or even maybe an applicant misrepresented his position, whether the applicant has a criminal conviction and they ask in the application, have you ever been convicted? And the applicant says no. And then it turns out that the applicant had actually been convicted. So in such a situation, the applicant may be eligible for waiver. Secondly, an applicant may have misrepresented facts. Maybe the applicant, in an attempt to obtain a visa, has lied about his or her employment. For example, maybe an applicant applied for a visiting visa. In the application, they ask for employer, and maybe the applicant lied. This is just an example. Maybe the applicant lied for that, oh, I work for XYZ Corporation. Maybe the applicant received the visa, got to the United States, and now decided to apply for benefit. Now, in applying for benefit, maybe the applicant now came up or stated the real situation, the real employer, or maybe the applicant is not even employed. And in the process of processing the application, maybe USCIS reviewed the application that was initially submitted by the applicant to the consulate and determined that the applicant lied in order to get the visa. In such a situation, the applicant will be inadmissible to the United States on the ground of misrepresentation. Another ground, maybe in the application for non-immigrant visa, maybe the applicant was asked whether the applicant has family members here in the United States, and the applicant says no. And then it turns out that the applicant has a family member. Now, those are grounds of inadmissibility. It could also be that the applicant has some criminal convictions, which makes it impossible for the applicant to get the benefit requested. Again, some of these things, the applicant may be eligible for a waiver. So in such a situation, the applicant will need to show, especially when it comes to immigrant waiver, the applicant will need to show that there is a qualifying relative who will suffer hardship if the applicant is not granted the waiver. Now, for immigration purpose, qualifying relatives means the U.S. citizen or permanent resident family member. Again, when we define family member for immigration purpose, it is different from the definition by English dictionary. In other words, to a U.S. citizen for immigration purpose, family includes the parents, the spouse, and minor children. Biological children that are 21 years old and above, they are not considered family member for immigration purpose. Therefore, they could not be a qualifying relative for the purpose of waiver. So, if an applicant is planning to apply for a waiver, the applicant will have to show that there is a qualifying relative who is either a U.S. citizen parent, a U.S. citizen husband or wife, or U.S. citizen minor children. Now, before I start answering questions, I need to quickly say this. Depending on the fact of the case, usually spouses, that is, husband and wife, in my opinion and my experience, it is easier to prove hardship to a spouse than proving hardship to children, any child that is above 15, especially children 18 years and above. It is always very difficult to prove hardship because of the unique system here in the United States. Here, although for immigration purpose, children are still a child, anyone under the age of 21 may still be considered a child. But the truth of the matter is that once a child turns 18, he or she is treated as an adult. He could vote. He could, most of the time, he will have left the home. He or she will have left the home, maybe go to college, or one way or the other be independent. So a child who is already independent is going to be difficult to prove hardship to a child through a child who is independent. So in other words, if your child is 18 years and above, let's say your child is already living on campus, is going to college, is already living in school. So what hardship are you going to prove? You no longer take this child to school. You no longer have to feed him or her. You no longer have to do basic things that you do for a 6 or 8-year-old to this child. So when you are using such a child as a qualifying relative, you will need to show more. You will need to show other extraneous factors like medical condition. Maybe the child has some unique medical conditions that requires you to take care of that child. That could be a form of hardship. But usually, it is easier to prove hardship when the qualifying relative is a spouse. I will explain that much longer. Now, the waiver that I've explained so far, talking about the immigrant waiver, this is assuming that the applicant, if the applicant is in the United States, it is assuming that the applicant entered the U.S. legally. If the applicant is outside the United States, it is assumed that the applicant does not have other form of inadmissibility. But for an applicant who entered the United States IWI means entry without inspection. Those who walk in through the border, they were neither admitted or paroled into the United States. They were never given a visa to come to the United States or parole at the port of entry. That is what is called IWI, entry without inspection. Now, if an applicant entered the U.S. without inspection, such an applicant cannot adjust status in the United States. An applicant who entered the U.S. without a visa, without being paroled, cannot apply for green card while inside the United States. So, even if the applicant is eligible for a waiver, the applicant will still not be able to adjust status in the United States. Now, the question is, how can the applicant now get green card? This is where waivers have categories. We have what is called I-601 waiver. That is waiver of grounds of inadmissibility, everything that I've explained so far. For those who enter the U.S. IWI, entry without inspection, their own kind of waiver is I-601A. That is unlawful presence waiver. So there are two different sets of waivers. So it is very clear that we understand this so that we don't mix things up. Unlawful presence waiver is for applicants who enter the United States without inspection, or applicant who have to go out of the US to process application for adjustment and has been unlawfully present in the United States, they will need to file I-601A, unlawful presence waiver, before such an applicant can come back to the United States. Now, for IWI applicants, those who entered without inspection, even if they get the waiver approved, the I-601A waiver approved, even if they get it approved, they will still have to go back to their home country, to the US Embassy in their home country, in order to apply for green card, in order to do what we call consular adjustment. But usually, once the unlawful presence waiver has been granted, when they go back, that issue of coming in here illegally or staying illegally will not be an issue. The issue will have been resolved. It will not prevent them from getting their green card. I think we are going to have to go to on a short break. I need to short break, please.
I cry with them because you feel what they're feeling. And you understand what they go through. And it, like I mentioned, like we all handle their case, we all know their cases. And it's like I am one of them, and I understand what's going on. And I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I held his neck because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in our face and we were able to get her substantial amount of money from the insurance company. Even after paying all our medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, I was, Nigerians, how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own, and we all celebrated. It was a good thing.
Another interesting thing. Welcome back. Sorry about that. I needed to take some water. Yes. So as I was explaining, for those who are unlawfully present here in the United States, they will have to apply for the I-601A waiver. So that is unlawful presence waiver. So it is important that we understand these different categories of waivers. Now, keep the questions coming so that at least I can attend to the specific question while still explaining this so that we don't waste a lot of time on this. Keep the questions coming. Again, this program is every Wednesday, 12 p.m. Central Standard Time. That is Dallas time. It is free of charge. Please invite friends, family. Let them also take advantage of this free information so that they avoid unnecessary mistakes. The only reason we are doing this is to ensure that people do not make avoidable mistakes. So log into our YouTube channel, subscribe to our channel so that when we go live, you can be notified and you'll be part of this. It is not good to be selfish. Let others also benefit from this information. Again, keep the questions coming. Keep the questions coming in. Now, talking about the waivers, the question is, how do we get the waiver approved? As I stated earlier, in order to get waiver approved, especially immigrant-based waiver, you will need a qualifying relative. Qualifying relative, that is, a U.S. citizen, parent, spouse, or minor children. Now, I was explaining earlier that it is easier to get a waiver approved if the qualifying relative is the spouse. That is, if the qualifying relative is the wife or husband of the applicant. The reason is very simple. When we talk about waiver requires an applicant to prove that the qualifying relative will suffer extreme hardship. In order to get the waiver approved. Now, the courts have interpreted this over the years, and they have concluded that every time somebody is deported, there are usually hardships that are associated with deportation. So that kind of hardship is not considered extreme because virtually everyone who has been deported or who may be deported will definitely suffer things like family separation. If they have a family here, they will suffer family separation. Everyone who has been deported or are likely to be deported or may be deported, they will probably suffer maybe substandard way of life, living standard, a lower living standard than that of the United States. So you cannot use those kind of excuses or those kind of grounds as ground for extreme hardship. Those are not extreme. Those are normal hardships that are associated with deportation. So if you rely on that kind of hardship, a waiver is likely not going to be granted. So when we are talking about extreme hardship, we are talking about a qualifying relative who has maybe substantial medical impairment. I remember there was a time some years back, I had a client that we needed to file a waiver, and the U.S. citizen's spouse, the spouse of the applicant, was at the time diagnosed with stage 4 cancer. The waiver application was approved within 30 days. As soon as we included all the medical documentations and everything, it was approved within 30 days. Unfortunately, that applicant passed. No, not the applicant, the qualifying relative. The qualifying relative passed. But of course, we were still able to get the spouse, the applicant. We were able to get her the green card. In fact, it was a multiple issue in that particular case because the applicant also entered the U.S. EWI without inspection. But to God's glory, we were able to do it. The point I'm making here is the requirement that an applicant will have to meet in order to show extreme hardship. From the word extreme, so there must be something unique. There must be something that is not common, something peculiar to the applicant's qualifying relative that may lead to the applicant being granted the waiver. It does not necessarily have to be medical condition, although medical condition will be a very good ground for proving extreme hardship. But in addition to medical condition, an applicant who is married to a U.S. citizen, they can actually use the fact of separation among other things, a cumulative factor. For example, why do people get married? One of the reasons people get married is companionship, sexual relationship. So if you are going to lose sexual relationship with this qualifying relative, if you are deported, or if you are going to lose companionship if you are deported, this may be considered. It cannot be on its own. It cannot be the sole reason for granting a waiver, but a cumulative items, this may be part of it. For another thing is financial situations. Maybe somebody who is married to a U.S. citizen and you are the one paying the bills. Your spouse, the U.S. citizen, maybe is either not working or has a very limited income. And you, as the applicant, you are the one that carries most of the bills. Of course, if such an applicant is deported or denied the approval of the waiver, the U.S. citizen may be in financial jeopardy. Again, this cannot be the sole reason, but it's a factor that can be considered as part of cumulative items, cumulative reasons for a waiver. So I'm going to suggest that every case is different. Waiver, just like immigration itself, is not a one-cap-fits-all. So it is always better if you find yourself in a position to have to apply for a waiver before you can get your adjustment approved or get your consular processing approved. It is better to consult an experienced immigration attorney so that they can guide you through this process. Okay, I just realized questions have started coming in. Okay, so the first question I'm going to read here today, I accidentally claimed that I'm a U.S. citizen on an application for an apartment, and USCIS found out. Is there a waiver for that? This is a very, very, very good question, extremely good question. I said extremely good question because the waiver that we are talking about is not applicable to every situation. It is not applicable to every scenario. For example, somebody who committed aggravated felony may not be able to get a waiver. Somebody who has been convicted of aggravated felony may not be able to get a waiver. In addition, someone who has falsely claimed to be a U.S. citizen may not be able to get a waiver. In fact, not even may. The law specifically prohibits someone who has falsely claimed to be a U.S. citizen from getting a waiver approved. There is no waiver for somebody who has falsely claimed to be a U.S. citizen. There is no waiver for somebody like that. The only thing I want to tell you, whoever sent this question in, what I'm going to tell you is that I've said this over and over and over again, that immigration is not a one-cap-fits-all. So you might want to consult an experienced immigration attorney to look into your peculiar situation. There is a reason why I said that. The answer to your question is simply no. There is no waiver for anybody who falsely claimed to be a U.S. citizen. That is the law. However, The law says that when someone falsely claims to be a U.S. citizen for the purpose of obtaining a benefit. So, this is where experience comes in. This is why you need an experienced immigration attorney. I'm not saying it is applicable in your case, but all I'm saying here is that it may be possible to show that although you falsely claim to be a U.S. citizen, it was not for the purpose of obtaining a benefit. Well, that would depend on whether it is a mandatory requirement for anybody to be a U.S. citizen before you can get an apartment, which, of course, I don't think so. I don't think you have to be a U.S. citizen in order to get an apartment. You may be able to get an apartment without being a U.S. citizen. You may be able to get an apartment without even being a permanent resident. So, again, it depends on a number of factors. So when someone experienced look into your specific case, you may be able to argue yourself out of that ground of inadmissibility, because the law requires that you falsely claim to be a U.S. citizen in order to get a benefit. So that is where the challenge is, and that is where the window of opportunity to make that argument, that is where the window is. So you may want to consult an experienced immigration attorney in order to find out if in your peculiar situation you may be able to get yourself out of this. But to simply answer your question, anyone who falsely claims to be a U.S. citizen, are they eligible for a waiver? No. The answer is no. There is no waiver for false claim to U.S. citizenship. Next question. When I was applying for a visiting visa to the U.S., the person who helped me apply told me I should put that I was married so it will get approved. I was single. Okay, one of two. Okay, let me keep going. I didn't put this information on my application to adjust status. Now USCIS has issued an RFE for the divorce decree for the marriage that was put on my visa application. What can be done? Well, it depends on a number of factors. To answer you, there are multiple sides to the answer to this question. Number one, someone who falsely claimed to be married when they are not, are they eligible for a waiver? Yes. The answer is yes. You could apply for a waiver in order to prevent the consequence of that action. You are eligible for I-601 waiver. Now, the other side, the flip side to this question, which I really don't know, it also depends on a number of factors. It depends on the information that you have listed in your non-immigrant visa application. It depends on whether you have taken steps to further, to add to the lies. It depends on a number of things. But the truth of the matter is that if you come out clean, are you eligible for a waiver? Yes, you are. If you meet the requirement of I-601A waiver, I-601 waiver. If you have a qualifying relative who can demonstrate extreme hardship, yes, you can do that. But what I want to be clear here is that whoever sending this question already has a pending application. It is likely, I'm not saying this for sure, but it is likely that this application is going to be denied, because you cannot claim in your application that you are single, claim in your visa application that you are married, and now when you apply, you didn't list that marriage. Immigration is the one that brought it up, and now you want to apply for a waiver. It doesn't work like that. The way it works is that you claim you are married when you are applying for waiver, when you are applying for visa, or maybe your agent or whoever represented you claim that you are married. Now you claim to the US. You know that you have never been married. So the question is, when you are completing your application, when you are submitting your application, did you come out clean? If you come out clean, that look, I've never been married, I'm single, never been married. The information on my non-immigrant visa application was a lie. I apologize for that, and I want to apply for a waiver. Yes, you'll be eligible for a waiver if you meet the requirement of the waiver, which requires your qualifying relative to show hardship, to prove hardship. Yes, you will be eligible for a waiver. So, what I'm going to suggest is, whoever writes this question, I will suggest that you consult an experienced immigration attorney to further look into the peculiarity of your case. There's one thing everybody listening to me must understand. This is a general platform. I may not be able to address specific case, because in order to address a specific case, I will need more information. And every information that I'm giving out now, this is based on the this is a general information based on the specific questions asked. So, are you eligible for a waiver? Yes. Is your waiver going to be approved based on this pending application? I doubt it. But again, go ahead and consult with an experienced immigration attorney so that you can get more information about this. Please keep the questions coming. Keep the questions coming. We are discussing waiver today. Waiver of grounds of inadmissibility. Whether you have been disqualified or inadmissible based on fraud, based on misrepresentation, based on criminal convictions, and what you need to do in order to get the waiver approved. That is what we are discussing today. Please keep the questions coming. So, talking about proving extreme hardship. Again, like I said, you have to have a qualifying relative who will show that he or she will suffer extreme hardship if the waiver is not granted. Now, it is always good, although not required, but it is always good to have multiple qualifying relatives. In other words, if you are married to a U.S. citizen or a permanent resident, your spouse could serve as a qualifying relative. But if you also have minor children, let's say you have children that are under 18 years old, yes, they could also serve as additional qualifying relative. If you have parents who are permanent resident or U.S. citizen, you could also use them as additional qualifying relative. So the more qualifying relatives you have, the better for your case. Although it is not required, if you have one qualifying relative that can show extreme hardship, that is sufficient. In fact, that is the only thing that is required under the law. You are only required to have one. You don't necessarily have to have multiple qualifying relatives. So you are required to have only one qualifying relative. What is important is for the qualifying relative to show extreme hardship. So once your qualifying relative is able to show extreme hardship, you will be fine. So that is very, very important to know and to understand. So keep the questions coming. Keep the questions coming. Keep the questions coming. Please keep the questions coming. Keep the questions coming. Okay, I think we have new questions. Okay, this one was sent in by WhatsApp. Good day, sir. What is the best way for a husband not to be denied a subsequent visa if the wife they got here together with a visiting visa decided to stay back and overstay while the husband went back after 4 weeks? Both are talking separation, and I need to know whether overstaying of the wife can affect negatively the husband visa application from him country of origin. Yes, the simple answer to this is yes. Even though this is not relevant to the issue of a waiver, but the answer to this is yes. If you obtain your visa as husband and wife or as a family at the US Embassy, and you came to the US as a family, if the husband decides to return home and the wife decides to stay and stay illegally, unlawfully, yes, the question is, will it affect any future visa application of the husband? The answer is very simple and straightforward. Yes, it will. It will. Because you obtain your visa together as a family, any renewal application, they will always link your family, your wife, they will always link the application. And once they pull the application and they realize that your wife did not return as promised, your wife did not go back to your country as you, I'm sure when you apply for visa in the first place, you probably told them how long you are coming to stay. Most people they will ask you, how long are you planning to stay? Some will say 4 weeks, some will say 3 weeks, some will even say 2 weeks. But even at that, at the port of entry, usually you may have been given 6 months at the port of entry. For as long as you stay within the 6 months, you are still okay. But the moment you exceed the 6 months, that is when you become unlawful. That is when you stay here illegally. And any subsequent renewal application, yes, the husband will be affected. The husband will be affected. If that is the question, yes, the answer is yes, the husband will be affected. I mean, because the embassy will continue to treat you as a family. So, whatever any member of the family does or fail to do will affect the other members of the family, especially considering the fact that visiting visa is 100% discretionary. Non-immigrant visas generally are discretionary. So this will be a discretionary ground to deny the husband the visa. The answer is yes. Another question sent in via text. Dear sir, I'm a nursing student on F1 visa. Can I self-petition with the help of a lawyer during my 1-year OPT after passing my NCLEX instead of going through nursing agencies? Thank you. The answer is no, sir or ma. The answer to this question is no. Nursing has its advantages. Nursing has the option, is one of the few professions that are exempt from the requirement of labor certification. But then it does not allow an applicant to self-petition. No. The fact that you are a registered nurse does not give you the opportunity to self-petition. So you cannot self-petition. You cannot self-petition. You need an employer to petition for you. You don't necessarily have to go through an agency. You can just look for an employment. Look for an employer to sponsor you. Especially if you already have your 1 year OPT, look for a job. So while you are working, you can get an employer. Whoever employ you during your OPT, you can request them to petition on your behalf. So agency is an option, but direct employment is also an option, but self-petition is not an option. So I hope I've been able to answer that question. So when you pass your NCLEX, you still need an employer to sponsor you. You need an employer to petition for you. Please keep the questions coming in. We are discussing waiver today. Waiver of grounds of inadmissibility. What can make you ineligible or inadmissible to the United States? What could make your immigrant visa application be denied or your green card application be denied? It could be denied based on misrepresentation. It could be denied based on crime. It could be denied based on fraud. It could be denied based on other grounds of inadmissibility. Many of these grounds, there are waivers for many of these grounds. So that is what we are discussing today. So how do you get the waiver approved? That is what we are discussing. And I said, you need a qualifying relative. You need an immigrant visa to be approved on your behalf. So if you are married to a U.S. citizen, before you could be eligible for the waiver, you need the U.S. citizen spouse to file I-130 petition on your behalf. So while the petition is pending, or if the petition has been approved, then you could apply for a waiver. If it is employment-based, while the petition is pending, or if the petition is approved, you could apply for the waiver. But if it is consular processing means that you are applying for green card or you are processing your green card through the embassy, then you need an approved petition before you can submit an application for waiver of grounds of inadmissibility. In addition to that, we have discussed the fact that you need a qualifying relative who will have to show that he or she will suffer extreme hardship in order to get the waiver approved. There are other requirements for waiver. We'll be discussing them one by one. But in the meantime, I have another question. Let me answer the questions. Now, I used a fake passport when I applied for a green card, and it was denied due to this misrepresentation. I'm now married to a U.S. citizen who wants to file for me. What can I do? Okay. Yes, these are the kinds of situations that we have been talking about. The first step, I don't know if whoever sent this question, I don't know if this person is applying for green card from inside the U.S. or if this person is outside the U.S. and is doing consular processing. Now, if you are inside the U.S., the first thing that your U.S. citizen spouse need to do is to submit an I-130 petition, is to submit a petition on your behalf, I-130 petition. If you are inside the U.S. and you are eligible for adjustment of status, then you can file the I-601 waiver concurrently with your I-130 petition. On the other hand, if you are in the U.S. and you entered IWI, or you did not legally enter and you are not paroled, then your U.S. citizen spouse will have to file I-130 petition on your behalf, and you wait for that petition to be approved before you can submit I-601 waiver. Again, if you are unlawfully present, if you entered IWI, in addition to this misrepresentation, you may need to file I-601A waiver, which is unlawful presence waiver. But this person who sent this question, you are actually within the category of people who are eligible to apply for a waiver based on the fact that you have provided. So the second aspect of this question that we now need to address is whether your U.S. citizen's spouse will be able to prove extreme hardship. This is where the issue is now. Are you eligible to apply for a waiver? The answer is yes. We already discussed that. The answer is yes, you are eligible. The second question is your U.S. citizen wife going to be able to prove extreme hardship? That is where the question is. I don't have any information about your wife, so I cannot make that determination whether your wife will be eligible for a waiver or not. But is your wife eligible to apply? The answer is yes. Are you eligible to apply for a waiver? The answer is yes. Do you have a qualifying relative that you can use who could prove extreme hardship? The answer is yes. Will your qualifying relative be able to prove extreme hardship? I don't know the answer to that because I don't know your peculiar situation. So I don't know whether your wife has any form of medical challenges that you can use. I don't know whether your wife has financial challenges that you can use. I don't know whether your wife has mental or psychological challenges that you can use. I mean, there are a lot of things that can be used, but again, this is going into the peculiar situation of your U.S. citizen wife. And I will advise you to consult with an experienced immigration lawyer in order to make that determination and in order to proceed. But the basic questions, are you eligible to apply? The answer is yes. Are you eligible for a waiver? The answer is yes. Is your wife eligible to be a qualifying relative? The answer is yes. Will your wife be able to prove extreme hardship? I don't know the answer to that. The next question, this was sent through email. For my application for adjustment of status, I was told that I needed to do a medical exam and needed COVID vaccine. This is against my religion. Am I eligible for a waiver? What will it include? Yes. The answer is yes. You may be eligible. But there is something that I need to point out here. There is something that I need to point out. This is a catch-22 situation. A catch-22 situation in that application for permanent resident, not the petition, application itself. I'm assuming that this person is married to a U.S. citizen, but application for permanent resident itself is different from the petition that your U.S. citizen spouse is filing on your behalf. The petition that the U.S. citizen spouse is filing on your behalf, that petition is called I-130, Petition for Alien Relative. Now, that I-130 petition, that is what gives you the basis to apply for adjustment of status. The I-485 application to register permanent resident or adjust status. However, the application for adjustment of status, the I-485, that application is a discretionary application. It's a discretionary application. Whenever the Congress gives immigration or the Department of Homeland Security discretionary power, and they use it one way or the other, and people challenge them in court, the court has consistently ruled that we cannot force someone who was given a discretionary authority. We cannot force them to use their discretion one way or the other. The moment we are able to force them to use their discretion one way or the other, it is no longer discretionary. That is the position of the court on discretionary issue. So the fact that I-485 itself is a discretionary application, someone may be eligible for permanent residence, someone may be eligible for adjustment of status, and he could still be denied in the exercise of discretion. What I'm trying to say here is that an application for green card can be denied in exercise of discretion. It's a discretionary application. It is not an application that could be denied and an applicant can file an appeal. It is not an appealable type of application. So it is a discretionary form of application. Now, the reason why I'm explaining this, because it's very important that we understand what we are doing before we take a step. The reason why I'm explaining this is that the law cannot force you to do something that is against your religion. But the same law that cannot force you, that law too cannot make you impose your own religion on others, including on immigration. So, if your religion does not permit you or does not allow you to take vaccine, you are entitled to your religious belief. But USCIS too, in the exercise of discretion, they may choose to deny your application for permanent residence in the exercise of discretion. That is why I explained that aspect, because this is not appealable. The application itself, I-485 application for permanent resident itself, it's a discretionary application. It is not something that could be appealed. So if USCIS denied it, despite your eligibility, if they deny it in the exercise of discretion, there is no appeal. You cannot challenge their decision in court. You cannot appeal their decision. So that's why I said at the beginning of this question that this is a catch-22 situation. Since I've been doing this, I have presented multiple situations to immigration where clients refused or declined to take medical examination or even COVID because of religious or personal belief. Immigration will never argue with you. They will never force you to do it. But I can tell you from experience, every single one that I have done, immigration has not approved it. Immigration has not denied it as well. Immigration is good at doing something. They will just sit on it and they will leave you with your religious belief. They will not approve and they will not deny. And there is really nothing you can do. Like I said, because it is a discretionary form of relief, there is no appeal. You don't even have the right as a foreigner to challenge immigration in court over the non-adjudication of the petition or of the application, sorry. If the I-130 petition is also delayed along with it, yes, the U.S. citizen can challenge immigration in court. The U.S. citizen can file mandamus petition in court. The U.S. citizen can go to court to ask the court to intervene. But if where immigration approved the I-130, you cannot do anything on the I-485 because the I-485 application by itself is a discretionary form of application. So, the long and short of this story is If I want to be honest with you, I will just go ahead and do the vaccine, take the medical, and get my green card. But if you believe strongly that you don't need it, immigration cannot force you to do it, but they may also choose not to approve it. And there's nothing you can do about that. I think there are other questions. Let's see. Okay. I have a question that is kind of the opposite of what you are saying. My spouse is a U.S. citizen and has an extensive criminal history. And USCIS is saying they are going to deny the case because his background includes sexual assault. I know he has changed and love him. Is there something we can do? Is there a waiver even though he's in the US citizen? Well, this is a completely different question. It's a completely different topic. It's a completely different scenario. So when we are talking about waiver, we are talking about waiver in terms of foreigners. U.S. citizens don't apply for waivers. U.S. citizens don't need waivers. So the waiver we are discussing here is only in terms of the foreigner. So if is it husband or wife? Let me see. My spouse. Okay. If your spouse is a U.S. citizen, so the question of waiver does not even arise. So I want you to get that clear. The waiver we are discussing, when we are talking about waivers, we are only referring to the foreigners. American citizens don't apply for waivers. I mean, you don't need a waiver to be an American. You're already an American, and that's it. So American citizens don't require waiver. So that is not applicable to U.S. citizens. Now, to answer the second part of the question, you said that your spouse has extensive criminal background, which includes sexual assault. I can tell you that the reason your application is denied is because your spouse committed an offense under Adam Walsh Act. That is a different ball game entirely. That is different completely from what we are discussing today. Adam Walsh Act, what that simply means is that anyone, it does not matter whether you are a U.S. citizen or not, anyone who committed a crime, who has been convicted of a crime under Adam Walsh Act, even though they may be a U.S. citizen, they cannot petition for anyone. If they do, the petition will not be approved. That is what Adam Walsh Act says. Now, what are the offenses under Adam Walsh Act? Those are offenses usually against minors, sexual offenses against minors, maybe child molestation, maybe child trafficking, maybe child pornography. Usually offenses, sexual offenses against minors. So anyone who committed any such offenses, it does not matter whether they are U.S. citizen or not, those type of applications will be denied. So that is Adam Walsh Act. So that is what is applicable in your specific situation. That has nothing to do with a waiver. U.S. citizens do not apply for waiver. Now, before I go, I don't know, is there any other? Okay, no other. Keep the questions coming in. Keep the questions coming in. Before I go into other questions, I want to advise you, whoever sent this last question relating to Adam Walsh Act, I'm still going to advise you to consult an experienced immigration attorney, because even though there are no issue of waivers when it comes to Adam Walsh Act, but you may want to consult an experienced immigration attorney who may look into the specific the peculiar situation, because the law requires that the 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 petitioner must have been convicted of Adam Walsh Act. So sometimes we see situations where someone was arrested for Adam Walsh related offense, but at the end of the day, they were convicted of a different offense. So in such a situation, you may have an opening to be able to argue that the petitioner is not disqualified. I'm not saying that is applicable in your case, but I'm just saying it is worth exploring. In addition, depending on the peculiar situation, an applicant may also be able to show that the petitioner has actually been rehabilitated. There are other requirements in order to prove rehabilitation. So the best scenario in this case, consult with an experienced immigration attorney who can help you look into the peculiar situation in this case and then advise you appropriately. That would be my advice. Please keep the questions coming. Please keep the questions coming. I think we have another question. Thank you so much, sir. Please, what is the implication of working without the authorization from my school while requesting for my OPT from USCIS? Background info. My school mistakenly gave me a CPT letter to get my Social Security to work, and they later told me that my accelerated program is not eligible for CPT. They told me I'm not supposed to be working right now and that I can apply for OPT when it is time. Can I continue to work? Well, you asked this question and you have answered the question yourself, but I don't know why you still want me to answer it when you have already answered the question yourself. The truth of the matter is that anyone who is on F1 cannot work more than 20 hours per week outside campus. Students are only allowed to work maximum of 20 hours per week on campus. Maximum of 20 hours per week on campus. So, if the school mistakenly gave you a CPT letter, that is the school's error. That was not your error. So if you use the CPT letter to get your Social Security, to get employment, that is the school's error. It is not your error. However, the moment the school notifies you, this is why I said you have answered the question yourself. The moment the school notifies you that, look, this thing was issued in error, please stop work. From that moment on, you cannot work. If you do, you will be in violation of your status. So just wait until the end of your program. When your program is closed, apply for, when your program is close to an end, apply for OPT. When you are granted OPT, then you can work. CPT is not for everyone on F1 status. As the name suggests, it is supposed to be curriculum based. CPT is supposed to be curriculum based. So if your curriculum does not require you to work full-time outside campus, then you are not entitled to CPT. If the school gave it to you in error, that is not your fault. That does not create any problem for you. However, the moment the school notifies you that this letter was issued in error and that you needed to stop working, from that moment on, if you continue working, then you will be out of status. The reason is very simple. Sooner or later, because now you have Social Security, sooner or later, USCIS is going to find out that you are working outside campus. And when they raise the query, the school is going to tell them that they issued it in error, but they have notified you that you should stop using it. So if you continue using it, then you'll be on your own, and of course you'll be out of status. So I think we have answered that. Okay, another question. On the new I-485 application, there are now questions about being inadmissible due to being a public charge. Can you please explain what they mean by this? Well, questions about public charge has actually been part of I-485 a long time ago. What they did now was just to expand it. It has always been part of I-485. But what they did is expand it. But when they are talking about public charge, it simply means that you are relying, you or your family, you are relying on the government to take care of your responsibilities. It could be housing, it could be financial assistance, it could be medical assistance. You are getting. The question is, are you getting any form of assistance from the government? The government in this case, it includes the federal government, the state government, the county, or even the city. So for as long as it's a government, the question is, are you getting any form of assistance from the government? But one thing I can tell you for free is that usually emergency medical benefit is not a ground of inadmissibility. It does not matter your status. If you have emergency medical concern and you are rushed to an emergency, and in the process, they process Medicare for you, or Medicaid, or whatever healthcare program they process for you in order for you to get that emergency care. Or even if they process it after you already got the emergency care, those kind of emergency medical does not serve as a ground of inadmissibility. Those ones does not disqualify you. But when you intentionally apply, even without any emergency, when you apply for a benefit, then you are receiving public charge. And of course, that may be a ground of inadmissibility. So that is what that means. Please keep the question coming. Keep the question coming. So as the name suggests, public charge, when you are taking money from the government, when you are taking benefit from the government, when you are not a U.S. citizen or you are not a permanent resident, and this was not done under an emergency situation, then you are considered a public charge, meaning that you are becoming a liability to the government in the U.S. Okay, another question from the email. My family-based green card was denied due to marriage fraud. I made a mistake before, but now I'm now in a real marriage with a U.S. citizen. Is there anything I can do? Well, when we are discussing waivers today. Now, there are certain things that the waiver we are discussing does not cover. Under the U.S. immigration law, there are three scenarios, there are three situations where it may be almost impossible. I'm not going to use the word impossible. That's why I said almost. Because whatever I say, I always want to leave the God factor. I have seen God work. So in multiple scenarios, I've seen hand of God. So I'm a believer in the power of God. So I always want to leave the God factor. So that is why I'm using that word. There are 3 scenarios where it is almost impossible for anybody to get green card in the US. 1, if somebody files what is determined by immigration to be a frivolous asylum application, such a person is permanently ineligible for any benefit under the Immigration and Nationality Act. So what that means is that if you file an application for asylum and immigration reviewed the application and they came to the conclusion after interview that your application is frivolous. Frivolous means fabrication, something that never happened, something that was fabricated. If immigration came to the conclusion that your application is frivolous, of course, you have a right to represent your application for asylum in a removal proceedings at the immigration court. If immigration court also came to such a conclusion that your application is frivolous, again, you still have the right of appeal to file an appeal to the Board of Immigration Appeal. If the Board of Immigration Appeal also concluded that your application is frivolous, again, you have the right to further appeal to the circuit court governing the state where you live. If after exhausting all of your appeal processes, all of your due processes, and the conclusion is that your application is frivolous, my brother, my sister, you are permanently ineligible for any benefit. So even if you marry the American president, or if you marry the daughter of the American president, you cannot get green card in the US. That is the law, except the Congress change the law. Until the Congress change the law, that is the law as of today. So frivolous asylum application. Now, the second reason why somebody may be permanently ineligible for any benefit is somebody who committed a serious aggravated offense. I use the word serious because aggravated offenses have categories. I mean, somebody who is convicted of an offense and sentenced to 2 years in prison for immigration purpose is aggravated felony. But at the same time, you cannot put such a person in the same category as someone who is convicted of murder, killing a human being, or somebody who is a terrorist, convicted terrorist. So they are in category. So for certain aggravated offenses, the applicant is permanently ineligible for any benefit. Even if they already have green card, they will take it from them. So that is the second ground under which someone may not be able to get green card. Now, I said 3 things. The third one relates to the question that you ask here, and that is marriage fraud. Now, the Immigration and Nationality Act, Section 204C of the Immigration and Nationality Act says that no petition shall be approved where the alien has conspired or has sought to obtain benefit by reason of a marriage entered into for the purpose of evading the immigration laws, or the alien has attempted or conspired to enter into a marriage for the purpose of evading the immigration laws. So what that means is that if after interview, after adjudication, immigration came to the conclusion that your marriage is fraud, your marriage was not a real one, your marriage was purely for you to get immigration benefit. If they make that finding in writing and after all your legal challenges, again, if immigration come to such a conclusion, you have the opportunity to appeal, to file an appeal to the Board of Immigration Appeal. Even if the Board of Immigration Appeal makes such a decision, you still have the opportunity to appeal further to the Fifth Circuit. So if after exhausting all your due process, this determination came to stand, it was confirmed that your marriage was fraud, the law, Section 204C of the immigration law says that no petition shall be approved. So what that means is that any subsequent marriage cannot cure this problem. The fact that you remarried somebody else for real this time around, that cannot cure the problem. In other words, it is a permanent problem. Now, having said that, does that mean that you cannot get a green card? That is not what I just said. I want you to understand me very clearly. The first two scenarios that I explained, it says the one who files a frivolous asylum application, that is a permanent bar. You cannot get green card irrespective of what you file. Whether you remarry, whether you do, irrespective of what you file, you cannot get green card. The second one that I said, certain aggravated felony offense, being convicted of certain aggravated felony. If you are convicted of those serious aggravated felonies, it does not matter what you file. Simply, you cannot get green card. That is it. But this last one, which affects your own situation, the law says no petition shall be approved. No petition. Note the word petition. It is not everything that we use to apply for green card that is by way of petition. So, you may be able, I'm not saying you in your situation you will, but I'm just letting you know that there is a window of opportunity. You may be able to avoid that permanent bar if what you file subsequently is not a petition. Let me give you an example. Again, I'm not saying that you are eligible for this because I don't even know the fact of your case, but I'm just giving a general answer. An example, somebody who has been determined to have entered into a marriage for the purpose of evading immigration laws. In other words, immigration has made a determination that you have entered into a fraudulent marriage and they have decided no future petition can be approved for you. Let's say such a person has been here in the US for not less than 10 years. Let's say such a person found himself or herself in removal proceedings. Let's say such a person has qualifying relatives, US citizen spouse, minor children, or even parents who will suffer extreme hardship if this person is removed from the US. Then, if all those three conditions are met, and okay, the fourth condition, let's say this person does not have criminal record. Then, if all these four conditions are met, this person, despite the 204C ban, may be eligible for what we call cancellation of removal. The process of cancellation of removal does not involve filing a petition. And because what the law banned in Section 204C is a petition, the law says no petition shall be approved. But because cancellation of removal does not involve the filing of a petition, you may be able to escape that permanent bar. Again, I will advise you consult an experienced immigration attorney who may be able to look into your peculiar situation and tell you if you stand any chance. think I've missed the other questions. Let me see. Okay. Okay. The next question. Please keep the questions coming. I'm enjoying it. Please keep the questions coming. The next question. My family. Oh, I think I just read this. Okay, this is the one I just answered. The next question by text. I'm a student under F1 status and my family applied for immigration under EB5 and I've adjusted status with my family concurrently. Assuming EB5 visa is denied for some reason, will I forfeit my F1 status or will I go back to my F1 status? Well, good questions. If my interpretation of this question is correct, the answer is no, you cannot. My interpretation of this question is that you were on F1. While on F1, your family filed the EB5 adjustment concurrently. The EB5 petition concurrently with adjustment application. Now, the moment you submit the I-485 application for adjustment, from that moment, you are no longer on F1 status. So that is the first thing you need to know. So F1 status is a non-immigrant status. It is not an immigrant status. I-485, the application to register permanent resident, which you submitted concurrently with your family, that application is an immigrant visa, is an immigrant status. So you cannot be in non-immigrant and immigrant status simultaneously. No, you can only be in one. You cannot maintain both non-immigrant and immigrant status concurrently. The only exception to that rule is H-1B. H-1B status is the only exception to that rule. So now, what I'm trying to explain here is that because you are on F1, the day that your I-485 was filed and you received the receipt notice from immigration, from that moment, you are no longer on F1. You have a pending adjustment application. And that is why I believe that your family must have applied for employment authorization and travel document concurrently for you. You are no longer on F1 status. So, coming back to your question, if for any reason the I-485 is denied, can you go back to your F1 status? No, you cannot, because you will no longer be eligible for F1 status. The reason you will no longer be eligible for F1 status is because one of the requirements of F1 status or any non-immigrant visa status is for you to show family, economic, and financial ties to your home country, to show that you do not have immigrant intent, to show that you are here to go to school, you are here on a temporary basis, and you need to go back upon completion of your program. That is one of the major requirements of every non-immigrant visa. Now, when you submit the I-485, you are telling immigration that you want to stay here permanently. You want to immigrate to the United States. You want to become a permanent resident of the United States. So the requirement of the two, they contradict each other. On one hand, non-immigrant, you are telling them you are here temporarily, you do not intend to stay, you intend to go back home. Immigrant visa, you are telling them you want to remain here permanently. So the two does not work concurrently. So you are no longer on F1 status. So if for any reason the I-485 is denied, then you will be out of status. But again, at that time, depending on your situation, there may be other options for you. But that option does not include going back to your F1 status. Let's see the next question. The next question. I have an approved I-130. I was in court. My case was dismissed, so I am done with the court. They said USCIS will adjudicate my case. I just had my I-601 approved recently. The I-601 was approved after the case was sent back to USCIS. I still have not had anything on my I-485 after multiple service requests. What can I do? Well, if I understand this question correctly, even though it's not very clear, but if I understand it correctly, my understanding of the question is that this case was dismissed to enable USCIS complete the process. Because when a case is dismissed, there are multiple options. There could be multiple reasons. A court may, especially since you have an approved I-130, a court may have granted you adjustment before dismissing the case. So if that happened, what you just need to do from that day that the court granted adjustment, whether immigration sent your green card or not, from that day, you are a permanent resident. But if, on the other hand, if immigration dismiss this case to enable USCIS adjudicate the I-485, then you are just back to the queue with USCIS. So you just have to keep doing service requests. You can, since you are married to a U.S. citizen, you can get your U.S. citizen spouse to also use what we call congressional intervention. So your spouse could go to your district congressman. They will ask you to give them your consent to discuss your case with USCIS. So once you give them your consent, they will contact USCIS through their congressional liaison office, and then sometimes it works, sometimes it does not, but there is no harm in trying. So your wife could do that as a U.S. citizen. Every congressman, they know that they will need people to vote for them every 2 years, so they probably will attend to your wife. And they also know that you are also a potential future vote for them if they help you. So all these things, sometimes they go out of their way to help, knowing that if they do it, you probably vote for them in the future. Yes, sometimes it works, but what can you do? You continue to do service requests. You can also seek congressional intervention. But I will advise you, before you seek congressional intervention, the first thing you need to look at, go and look at the processing time. Because if the processing time is still, if the case is still within processing time, USCIS will just tell your congressman that this case is still within processing time. And of course, even if you do service request, it will still be the same thing. They will tell you this case is still within processing time. We are not ready for a decision at this time. But if you check the processing time and the case is outside processing time, that will be a good case for congressional intervention, and it will also be a good case for multiple service requests. So I hope I've been able to answer that question. Please keep the questions coming. We have about 25 more minutes to go. Keep the questions coming. Keep the questions coming. Yeah, I think I answered. I hope I didn't miss anyone. Yeah, please keep the questions coming. You can text your question on our WhatsApp number 817-983-4499. You can text it. You can send it on WhatsApp. You can call in. You can call the same number live, and we will answer the questions. So keep the questions coming. Today we are discussing waivers. Waiver of grounds of inadmissibility. I-601 waiver. As I said before, in order to be eligible for a waiver, you must have, the applicant must have qualifying relatives. Qualifying relatives means U.S. citizen or permanent resident, parents, spouse, that is husband and wife, or minor children. Minor children, meaning children under 18. Minor for this purpose is not the same thing as children under 21. For immigration purpose, minor is anyone who is under 21. But for waiver, the reason we always stick to under 18 is because when a child is 18 years and above, immigration will not see any hardship that that child will go through. Based on the American system, based on the social system here in this country, when a child is 18, such a child is treated as somebody who is capable of taking care of himself or herself. That is why at age 18, a child is able to vote, because they believe that a child can take a decision on his or herself, on his or her own. So most of the time, if this child is in college, there is a probability that the child at that moment is living alone on campus or outside campus. So they are not going to see any extreme hardship that the child is going to suffer because of you. They will tell you, if this child is already living independently, he or she is not going to go through any extreme hardship because of you. So that is why we always restrict children for the purpose of qualifying relative, for the purpose of waiver. We always restrict the age to 18. However, even a child that is above 18, they could be used as a qualifying relative. Even a child who is above 21, if they have significant medical condition, if they have or if they are a special need child, which will further show that if you are the primary caregiver of this child, definitely removing you from the United States is going to cause a substantial amount of hardship to such a child. That could be used for extreme hardship purpose. So every case is different. This is not a one-cap-fits-all. So you need to analyze your peculiar situation. You may also have somebody without any medical condition, and the waiver can still be approved, especially if the person is a spouse and you are able to prove cumulative factors such as absence of sexual relationship if you are removed from the United States, such as companionship if you are removed from the United States, such as psychological effect on your partner if you are removed from the United States, financial burden if you are removed from the cumulative factors could also be considered in order to get the waiver approved. So let's go to the next question. I have been charged with 2 DWIs, but my child, 9 U.S. citizen, is very sick and need my care, like what you just said. I think this person is still typing, so I'm waiting for. Okay. Can I file a waiver? I'm not married, but I have another U.S. citizen child that is older. Well, I don't understand this question because, as I explained at the beginning, because before you can talk about waiver, you need to have an immigrant visa approved or pending on your behalf. So, if you are not married to a U.S. citizen, who is filing the petition? What petition are you going to rely on? Waiver is not something that you can do on its own. It is not a standalone thing. waiver is usually based on a pending or approved immigrant petition. So before you can file a waiver, you need someone to file a I-130 petition on your behalf, or I-140 in the case of employment-based. So you need a petition to be filed or approved on your behalf before you can talk about applying for a waiver. So what is going to be the basis of the waiver? So if you are not married, there's a okay. I think there's an additional clarification. Okay. Can I file a waiver? I'm not married, but I have another U.S. citizen child that is older. Okay, can my adult child file the petition for me? Oh, okay. Now you are making more sense. If your adult child is a U.S. citizen and is 21 years and above, yes, your child can file the petition, the I-130 petition on your behalf, and then your 9-year-old who requires your attention, who has the medical challenges, could serve as your qualifying relative. Yes, this is very, very possible. Yes. The answer to your question is yes. Your older child, for as long as he's 21 years and above, he can be the petitioner, file the petition on your behalf, and then your 9-year-old who is very sick can serve as your qualifying relative. So yes, the answer to the question is yes. So keep the questions coming. We have about 20 more minutes to go. Keep the questions coming. Keep the questions coming. Okay, I think another one just came in through a text. Thank you for what you are doing, sir. I'm currently on my STEM OPT program, IT field, and my wife is about to finish her nursing program in 5 months. Okay, I'm waiting for more information. Keep the questions coming in. Keep the questions coming in. Okay, I think I have the full question now. Thank you for what you are doing, sir. I'm currently on my STEM OPT program, IT field, and my wife is about to finish her nursing program in 5 months. Will you advise that we file our adjustment of status based on my wife NCLEX, or should we file national interest waiver? Okay, this is a very good question, and is a good problem to have, as in when you have multiple ways of adjusting, multiple ways of applying for a green card, is a very good problem to have. However, let me give you a straightforward answer. A straightforward answer based on the situation of the law today in the US, I will advise you to go with your wife's NCLEX. Based on the current situation right now, I will advise you to go with your wife's NCLEX. And I will tell you why. Number one, your NIW application, that is under EB2, National Interest Waiver. As at now, EB2 has retrogressed. Visa is not current. EB2 has retrogressed as at today. So what that means is that as at today, you cannot submit application for adjustment of status under EB2. So even if you are going to apply for national interest waiver, as at today, you can only submit the petition. You cannot submit application for green card. You cannot submit application for employment authorization. You cannot submit application for travel document. You see, visa bulletin is something that changes monthly. And sometimes we cannot predict what is going to happen. Even USCIS themselves, they don't have control over this. The reason this thing is like this is that the Congress with the exception of petition based on immediate family. Petitions that are based on immediate family. That is the only exception. For every other petition, every other type of petition, there are numerical limits. There are numerical limits to the number of green cards that immigration could approve annually. So this limit is given by the Congress for family-based. Outside, with the exception of immediate family, the number is 225,000 per year. For employment-based, the total number is 140,000 per year. Now, that 140,000, that is what is going to be shared between EB1, EB2, EB3, EB4, and EB5. So that entire 140,000 will be shared among that 5 categories. They are not shared equally. You need to understand that they are not shared equally. Some of them get about 7% of that 140,000. Some get higher percentage. They are not shared equally. And of course, they are also not shared equally among countries. Some countries that are considered having high migration rates to the United States are treated separately. For example, in employment-based categories, India is treated separately. Philippines is treated separately. Mexico is treated separately. So countries that have high migration rate into the United States, they are treated separately. So all these things are taken into consideration in coming up with a visa bulletin. The Congress empowers the Department of State to come up every month with where we are on the queue. Any application that is filed, irrespective of the category, whenever the application is submitted to immigration and immigration issue a receipt, the date that application is received, that is what is called priority date. That is the date that the applicant joins the queue. Now, every single month, the Department of State comes up with where we are on that list. So they can tell you, as of March 2023, we are processing in the EB2 category, for example. They can tell you we are processing cases that were received in July 2022. So when we get to next month, when we get to April, they are the one that will tell you that, you know what, visa is current now. Anybody who submit their petition right now or their application for permanent residence, you can receive it now. They can get to May and tell you that, you know what, the number of applications we receive in April is too much. Therefore, we have gone back to treating applications that were submitted in December of 2022. So this visa bulletin, it moved forward and backward. When it moved backward, that is when we use the word retrogressed. That is when visa retrogressed. So to come back to this question, visa for EB2 national interest waiver is no longer current as at today. So you don't even have the option of filing for green card for yourself under EB2 national interest waiver as at today. I don't know what is going to happen 2-3 months down the lane, but as at today, visa is not current. So if you have the opportunity for your wife's NCLEX, please stick to it, because EB3 is current, but EB2 is not. So I believe that I've been able to answer the question extensively. Second question, okay, probably from the same person. Do the USCIS give priority to I-485 based on nursing petition than national interest waiver? Thank you, sir. Anyway, I believe I already answer all these things from all my explanation. They don't give priority to anything other. It depends on the category. So the issue is if your category, if visa is current, EB2, national interest waiver, and nursing, they are not in the same category. National interest waiver is in the EB2 category. Nursing NCLEX is in the EB3 category. So as of today, like I said, you know what? Because today is 20 something, I'm sure that visa bulletin for April will have been released. Let me just check since we are still live. So visa bulletin for April, I'm sure will have been released. So let me just check so that I can give you a definitive answer, because my answer was based on the visa bulletin for March. Okay, April has been released. So let's see. Yes, I was still right. Yeah. In actual fact, EB2 actually retrogressed further. As at March, it retrogressed to November. And now I'm looking at it, it has retrogressed to July 2022. That is EB2. Whereas EB3 is current as we speak. EB3 is current. So I hope I've been able to answer your question. So it's not about giving priority to one over the other. It is about visa availability. So is visa current for national interest waiver? The answer is no, it's not. Again, from my explanation, the reason that national interest waiver probably retrogressed further in April was probably because immigration received more application in the next month that is higher than the number they received in the previous month. So that is when visa retrogressed. And we don't have a way of knowing this information ahead of time. So maybe in January, maybe immigration received only 50,000 applications. Maybe in February, they received 120,000 applications. Maybe in March, they received 200,000 applications. Maybe in April, they received 45,000 applications. So we don't have a way of knowing all these things. But these are the things that the Department of State takes into consideration in determining when a visa is current and when it is not. And based on the information available today, visa is not current for EB2 category. However, visa is current for EB3. Therefore, the nursing aspect is your best bet. We have about 6 more minutes to go. Okay, another question. Is someone that applied for K1 visa eligible for an inadmissibility waiver if the consular officer found them inadmissible? Yes. The answer is yes. Very straightforward. For you to be eligible for a waiver, you need to have a qualifying relative. And if you apply for a K visa, it means you have a U.S. citizen fiancé. However, if this person is still in his or her home country as a fiancé, my advice to you will be, in order to stand a better chance of getting the waiver approved, go ahead and marry your U.S. citizen spouse. If you are in your home country, let your spouse come there to join you, get married, submit I-130 petition, and then you'll be able to apply for a waiver. But if you already have the K1 status, yes, your fiancé can also serve as your qualifying relative. But remember, even if you have the K1 visa, you have you have 90 days to marry. If you come to the United States on a K1 visa, you have 90 days to marry. So either way, you still have to get married. So go ahead and get married, and then let your spouse file the I-130 petition on your behalf. If you are in the United States, you can do it concurrently with the I-601 waiver. If you are outside the United States, you wait for the waiver to be approved, and you then apply for the I-601 waiver. So, to answer your question, yes, you are eligible to apply for a waiver. So, if there are more questions, keep them coming. We have just about 4 more minutes to go. It's been very interesting, and like I said, invite family and friends. Let everybody know about this program. We do this program every Wednesday, 12 p.m. Dallas time. That is Central Standard Time. It is our desire to provide information to people so that they avoid simple errors. So that we avoid simple errors. So it is our intention to make people avoid errors, avoid mistakes. So if this program is useful to you, bring in other people. Don't be selfish. Bring in other people so that other people too can benefit from it. So don't be selfish. So if there are more questions, I'll be willing to answer them before we round up. So keep the questions coming. We still have a couple of more minutes, so we can still answer a couple of more questions before we go. But most importantly, if you are enjoying this program, invite your friends. Send them the links when you receive it. Subscribe to our channel so that when we go live, you get notification. When you get the notification, forward it to your friends so that they too can benefit from this. We have no idea who may be helped or who may receive some valuable information from this. But it is very important that we are not selfish. So we are doing this free of charge. We are not charging anybody who log in. The information is there free of charge. So it is not fair on your part to keep the information to yourself. So circulate it, invite family and friends. Let them also know that we provide this free information so that they could also benefit. Subscribe to our YouTube channel so that when we go live, you get notification and you invite your friends. In coming weeks, if you have specific question or topic that you want us to discuss, you can send a message to us on 817-983-4499. 817-983-4499. It's a WhatsApp number. You can send your message through WhatsApp. You can also send your message through a regular text message. You can also call if you are more comfortable calling to explain your question or your topic. You can do all that. If there is an interesting topic that you want us to discuss, please send your notification ahead of time. We will consider it. And of course, one thing we will always do is to answer questions that majority of people, or to discuss topics that majority of people want us to discuss. Topics that are generally beneficial to majority. So, we will be rounding up now. We've been doing this in the last 2 hours. So, join us again next week, Wednesday, by God's grace, 12 p.m. Central Standard Time. That is Dallas time. So, you can send in your questions. What's that? Another question? Oh, I didn't say that. Oh, okay. Someone just sent a follow-up question. Let me quickly answer it before we round up. Follow-up on K1 visa question. If a K1 visa is taking too long, is it then okay to get married in my country and then have my then spouse petition for me? Sure. The issue here is K1 has its advantage and it also has its disadvantages. So usually, as an immigration lawyer, the advice that we give clients depends on whether the client is the US citizen or the beneficiary. Usually, we don't give them the same advice. We explain the benefit when our client is the US citizen, we explain the benefit of K1, going through the route of K1. When our client is the foreigner, we explain the benefit and the disadvantages of going through a K1. So, if I'm assuming that the person who sent this question is the foreigner, yes, your best bet, go ahead, get married, and let your wife file a petition on your behalf. If the person who sent this question is the American citizen, stick to the K1, don't get married yet, stick to the K1, wait it out, let your spouse, let your fiancé come to the US on a K1 status. I will not say more than that at this stage. Thank you again. We have come to the end of today's program. Join us again next Wednesday. This program, by God's grace, will continue every Wednesday for as long as we are still alive. Every Wednesday, Central Standard Time, that is Dallas time. Join us on YouTube. Join us on Facebook. Send in your question. You can send questions live during the program as we have done today. You can send your question through WhatsApp, through our text message, WhatsApp number 817-983-4499. 817-983-4499. You can send it through a regular text. You can send it through WhatsApp. You can also call to ask your question. If you have a topic that you want us to discuss, you can send in your questions or your topic ahead of time. We will consider it and then we will take note of it. Thank you again for watching. Don't forget to subscribe to our channel so that when we go live, you'll be notified. And don't forget to invite family and friends. Thank you.
I was looking for Lawyer Asekun for help concerning my immigration status because everything was upside down. Because I couldn't believe, I was even thinking maybe I'll be sent out back to Nigeria. So on getting to know him, he explained everything to me, what I'm going to do, that he's going to do everything. So fortunately for me, everything was done from him. Dr. Lawyer Asekun is the best lawyer so far in Texas because I can introduce as many as whoever is having problem, especially when it comes to immigration. I'm going to introduce Lawyer Asekun because he's the best lawyer. So far, so good.
Our goal here is to make our clients happy, especially in the area of immigration, family law, and personal injury.
I was looking for Lawyer Asekun for help concerning my immigration status because everything was upside down because I couldn't believe.
The principle was that it was a man that you can rely on. They work with me, they work with me like, it became something like family, right? It was no longer like, okay, this is a client, this is somebody it's providing you service, right? So it became something like a family. So yeah, I can see the relationship was good working with his staff. People give me encouragement, but I will look at it and say, how is it possible? You know, I said, it is not going to be possible. That's why I kept telling myself that it's not going to be possible. But him, he knew what he was doing. Like I said, research is very, very important. You know, if you do research, you will learn a lot of stuff. You know, there are a lot of immigration rules some people don't look at. You know, there are loopholes there, and sometimes they purposely put them there. You know, so it's research, and he's using this research to help a lot of people. Not just me. It is not just me. It is a lot of people here that, many people here that he has helped. Many people. Sometimes it doesn't even charge them. You know, when it comes to the point that it doesn't even charge them. You know, so yes, if you are looking for an immigration lawyer, you know, even if I'm sleepy right now, if I'm like sleepy, you wake me up, you say, do you know any immigration lawyer? I won't even blink, you know, I will say it, Dr. Asekun is there, you know, I will just say it. So, yeah, that's how good he is.
Talking about immigration, as an immigrant myself, I always put myself in the shoes of clients because I've passed through the immigration process and I know how hard it can be on people when they don't have the legal documents to work or to do day-to-day activities here in the United States. So that personal touch makes a big difference.
The law office of Olu Asekun is special because we like to put ourselves in our client's shoes.
For Dr. Asekun, for me, I will forever be grateful, and I keep telling people he's the best immigration lawyer you can have. You know, he's the best immigration lawyer you can have. My first impression was that he was a man that you.
Another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work. Because like I told you, I'm like a member of this family. And call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I was okay, I'm coming to your office. He said, okay, but just drive carefully and things like that. So okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, wow, the balloon just busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through, and it, like I mentioned, like we all handle their case, we all know their cases, and it's like I am one of them, and I understand what's going on, and I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I pared his neck because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in our face and we were able to get her substantial amount of money from the insurance company. Even after paying all her medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, you know, Nigerians, you know how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own. And we all celebrated. It was a good thing.
Another interesting thing about our office